All right, good morning, everyone. I'm Nancy Cope, a magistrate judge in Las Vegas. Today's panel navigates the legal waters surrounding podcasts, a medium that has become increasingly influential in law, media, and public discourse. As podcasts grow in reach and become a major platform for storytelling, news, and legal commentary, they raise a range of legal questions, from intellectual property and defamation to privacy, ethical risks, and regulatory concerns. In a world where anyone can hit record, the line between free speech, liability, and ethical responsibility is blurrier than ever. We're lucky to be joined today by an all-star panel. We're moderated by Davis Wright Tremaine partner Dan Laidman. We also have Wall Street Journal's Rachel Humphreys, Spotify senior legal counsel Whitney Potter, USD law professor Dov Fox, and NYU law professor Melissa Murray. There will be some time for questions at the end. You have cards on your table, so you can fill out the cards. You can raise your hands and the cards will be picked up, or you can bring them to our front table and we will pass them up to the panel. So thank you, everyone. Let's begin.
Well, thank you very much, Judge Cope. It's an honor to be here, and I would just reiterate what the judge said about Q&A. We're going to leave time for a robust Q&A session, and we really encourage all of you to submit cards. We want this to be a lively discussion that you're all a part of. But first, if you'll just indulge me for a second to just get a little bit highfalutin, I wanted to start off with a quote from a case, a 2012 decision called Lee versus Salazar, where some very wise Ninth Circuit judges said, quote, "The free press is the guardian of the public interest, and the independent judiciary is the guardian of the free press." And so today, with everything going on, I think it's more important than ever for these two pillars of our democracy, the independent judiciary and the free press, to really try to understand one another's work. And of course, it's through the media that the public most often learns about the work of the judiciary and what's going on in the courts of this country. And here in 2025, that often increasingly is done through podcasts. Podcasts have just exploded in popularity in recent years. And in particular, the public seems to have a limitless appetite for podcasts about legal issues, be it true crime, analysis and commentary about the Supreme Court, investigative reporting or narrative stories about legal matters. These are some of the most popular podcasts, and it really is how the public these days increasingly is learning about the work that the judiciary does. And so we're very fortunate today to have a great cross-section of speakers who have experience in all of these areas, who can talk about how they've used podcasts to communicate with the public about legal issues, and on the flip side, about some of the issues that might make its way to some of your courtrooms that come up in the course of podcast production. So, first, we have Rachel Humphreys. Rachel is a journalist, podcast producer, and host who currently serves as senior producer for the Wall Street Journal's podcast, The Journal. Rachel recently produced The Trial of Crypto's Golden Boy, a Wall Street Journal podcast that covered the trial of Sam Bankman-Fried, a high-profile cryptocurrency entrepreneur who was convicted of fraud in late 2023. So let's start off by hearing a couple of clips from Rachel's podcast.
Day 2 of Caroline Ellison's testimony, former CEO of Alameda. She's been on the witness stand all day being questioned by the prosecution, and we had tears at one point.
Yeah, at one point she was recalling pretty much the week that Alameda and FTX collapsed, and she started crying. Someone had to hand her a box of tissues on the stand.
And apart from that, we also had her testifying about Sam Bankman-Fried directing her to bribe Chinese officials. She testified that Sam Bankman-Fried blamed her for Alameda's losses, and she testified to Bankman-Fried directing her to lie to investors and to lie on social media about the true state of affairs at Alameda and at FTX.
Yeah, there was a lot today of her kind of outlining what Bankman-Fried knew about Alameda's financial positions, what he told her to do in terms of loan repayments, him allegedly trying to put blame on her.
Yeah, it was a lot, a lot to take in. How would you say this day has gone for Sam Bankman-Fried and his defense team?
That's the thing that I think we're really still trying to figure out. There wasn't really a main smoking gun. There wasn't necessarily a message from Bankman-Fried saying, I know this is all wrong, but go ahead and do it. But there was a lot of really major testimony from Ellison on all the different points she said happened in this journey. This is the trial of crypto's golden boy. I'm Caitlin Ostroff.
And I'm Rachel Humphreys.
Coming up, Caroline Ellison's side of the story.
I think we have one more clip that might be of particular interest to a
So
lot of
we've talked a lot about Sam Bankman-Fried ahead of this trial, but there's one other person who's going to be very central to this case. Who is that, Rachel?
The judge, of course, Lewis Kaplan, who is going to be the judge in this case, and will be a name I think that we mention a lot on this podcast going forward. He's very experienced. He's been a judge for decades, actually. He was nominated by Bill Clinton and became a US District Court judge in 1994. And being a judge in a federal court in New York, he's pretty busy. He deals with a lot of cases. And I actually found this clip of him speaking at an NYU law school event in 2016 where he talked about his caseload.
The day I reported for duty, in 1994, there was on my desk a note from my good friend from practice, then Judge John Martin. Dear Lou, congratulations. There are 400 cases on your docket this morning. There will be 400 cases on your docket the day you die. Pace yourself.
Okay, so we'll definitely want to ask more about this particular project, but Rachel, before we get into that, maybe if you could just tell us about, as someone who has a background in traditional broadcast radio journalism, how you got into podcasts and what you see the role of podcasts in kind of like current journalism.
Well, thank you, Dan, for that introduction, and it's an honor to be on this panel with so many esteemed speakers, and an honor to be at this conference today as someone with no legal training or legal background. I feel very intimidated in these rooms, but everybody's been very welcoming. As you mentioned, I began my career actually in live phone-in talk radio, which is a baptism of fire, and after a few years of being shouted at by the general public, I was ready to go freelance, and I did so in 2017, right as the podcast boom was really taking off. And the word podcast is an amalgamation of iPod and broadcast. These are portable broadcasts, and it really puts the listener in control. You can decide when you listen to something, what you listen to, how you listen to it. And it also has a much lower barrier to entry. Anyone can make a podcast. Any of you could pull your phone out now, record something, upload it to the internet, and call it a podcast. So it's an amazing medium in many ways. And for the last 7 years, I've been working in making podcasts for newspapers. I'm currently at the Wall Street Journal. We make 5 episodes a week, each one about 20 minutes, about one story a day. And what's amazing about it is it's such an intimate medium. It brings audiences into close contact with reporters. And for the first time, like traditional newspapers, their reporters have become much closer to their audiences. And this is an audience which typically skews much younger than traditional newspaper subscribers. It gets a younger audience, much more engaged in quite hard news subjects. And so I think that's been a huge transformation that many news organizations have found to be very positive.
And so for this project in particular, where you were basically providing, ongoing trial coverage for the high-profile matter in the Bankman-Fried trial, how did the podcast format, how was that a good fit for this type of trial coverage as opposed to more traditional means of covering?
It's really interesting, Dan, asking that question, because we're having a lot of conversations in my industry right now about format. Right now, podcasting is moving into vodcasting. Many podcasts are becoming video as we meet the demands of an audience that increasingly get their media coverage through the phone, through vertical video. But when we made this podcast in 2023, audio felt like the best fit because we were reporting on a trial at the SDNY where there were no electronics allowed inside the courtroom. And so we wanted to be able to make this podcast immediate for our audience and bring them into a courtroom that they were not able to get into. And it seemed like audio was just the best way to do that. Myself and my co-host, Caitlin Ostroff, would go to court every day. I had to get much better at handwriting, and we would come out with a huge amount of information. And as others on this panel, I'm sure Dove and Melissa will say this, audio is a fantastic medium for communicating complex and large amounts of information. And what we did in this podcast is we would decide what were the sort of most interesting things of the day. We would decide what we needed to explain to people. And then my colleague and I would put that in a conversation. And you can hear in the clips there, we would make it sound very casual and very conversational, but this would be something we would think a lot about. And I think that audio is just such an amazing medium for that. And it also meant we could talk about a lot of different things. One of the things that came across in this trial is that audiences really wanted to know what was happening in the courthouse. What were we eating? What's the canteen like? What are the court artists like? And some listeners were so interested that they actually turned up at the trial, which was a little confronting, but they were so engaged in what was happening that they wanted to see it for themselves. So that was a very interesting byproduct of what we were doing.
Well, actually, on that point, when you talk about people showing up at the trial, did the media coverage itself come up in the course of the trial, or was there an awareness that the coverage was affecting the trial in some way?
I mean, with this particular trial, for those that are not familiar, the defendant, Sam Bankman-Fried, it was largely on trial partly because what he had said to the media. Media coverage was a huge part of the trial itself, and so many of the journalists sat on the back benches, were quoted during the trial, were brought up in evidence. So I think that relationship was very close. But I think it was everyone covered it very professionally. It was a real mix because you didn't just have traditional journalists like us from a media outlet, you had a lot of crypto vloggers, you had people outside making videos every day. And so I would say the courtroom was very orderly, the overflow room was something a little different.
Right. I guess in any sort of reporting on a trial, no matter the medium, there's going to be a challenge where the participants are limited in how much they can say to you directly, and obviously, criminal defendant and their defense team are typically going, and prosecutors are typically going to be limited in how much they're communicating with the press during a trial. But it seems like with podcasts, there's a unique element there, which is this sort of intimacy with the listener. It's almost, I think we all have the experience of having a parasocial relationship with our favorite podcaster, and it's really about characters, and you feel like you have a relationship with the people who are being discussed. So how did you deal with that? We're really trying to make the subjects, characters for the audience when there are these unique challenges with covering a legal proceeding where the first reaction is, don't talk to the press.
We were very fortunate in that the subject of the trial was someone who was very known before the trial, and so audiences that came to our trial coverage were already very engaged, I think, in him and what he'd been doing. But yeah, it is a challenge. In audio, we really love to tell stories through characters whenever we can, through a human story. Sam Bankman-Fried doesn't just have an interesting story, he also at the time was a very interesting way to talk about the collapse of the crypto industry. And so wherever we can do that, we will. But it is very hard, as you say, in a trial where we can't speak to anybody. And so it was about being very descriptive in the courtroom. I spent a lot of time noticing people's movements, how people were reacting, and we would be very careful to point out to the audience what was important and what they would look out for. But that intimate medium was so helpful to us because people really trusted what we were saying. That's one of the things that's been so transformative for journalism, is that journalists and news organizations want audiences to feel like we are a trusted source, and podcasting helps you do that so much more easily, I think, than the written word does.
And so we heard the clip about Judge Kaplan, and so I think it'd be of particular interest to this audience about how you cover judges as opposed to other public figures, given the circumscribed nature of their role and what they're able to say publicly and how they're able to communicate. But again, with the podcast, it's really the characters are front and center. And so how did you deal with that, and in general with covering judges?
You know, judges are a real challenge for journalists because we would love everyone to do an interview with us, and obviously judges don't do that. So before this trial, Judge Lewis Kaplan, who was presiding, we sat down and we had to think about how are we going to communicate his character and who he is to people, because we're going to be talking about him a lot through this trial. And so as you heard there, I managed to find a clip of him on YouTube. He's a very smart speaker, very quippy, which was helpful. And I also interviewed an attorney who had been in his courtroom, and she gave us a very colorful image of what he was like. And I think that was really helpful for us in building up a picture of him. It was very important to us to explain to the audience what the role of the judge was during this case, because I think, and from feedback that we got from the audiences, there's a lot of confusion about what the judge actually does in a case, and also just how the courtroom works. And so one of the things I didn't really think about before we went into making this is that this podcast became as much about Sam Bankman-Fried as it did about how a courtroom actually operates, and we had to explain that, and people were very interested to understand more.
Right. And then we also heard the clip, obviously, from outside of the courthouse, and you're reporting on the day-to-day developments in a conversational way and in almost like a real-time way. And so when you're doing that, how do you deal with the legal risks that can come up from reporting on something like this, and verification, fact-checking, all of these things that go into any sort of reporting on a complicated issue like this, but in an audio format in a fast-moving way?
Yeah, that's a great question. And I think, as a Brit, where we have very strong contempt of court laws, that's something that I have been trained to think about a lot more than necessarily I always would here. But making this podcast, we wanted it to sound very live and very immediate. But I think the secret was that we really scripted everything. I always made sure that we were writing things down. We have an amazing team of editors and lawyers at the Wall Street Journal and many great legal reporters who would check our scripts. And so I would spend a lot of time in the courtroom actually drafting scripts during the evidence while my colleague took notes, so that we could send that over to our team as soon as we got out, have that approved, and then read it right there on the court steps, because you really want to avoid any risk, and you want to make sure that everything is factual and legally correct. And so that's something that we really kind of stuck to. And you make your scripts sound conversational. You bring them alive to make sure that you're bringing people into the conversation and not isolating them, but still sticking to those facts that are so important.
Great. Well, on that note, when we're talking about legal risks and lawyers who have a role in this, let's hear from our next panelist, Whitney Potter. Whitney's senior legal counsel for original content at Spotify, where she handles intellectual property, production, content, and transactional issues for the company's podcast portfolio. She was previously assistant general counsel at Refinery 29, director of business and legal affairs at Vice Media, and an in-house attorney at Starwood Capital Group. So Whitney, it's great to have you today. Maybe if you could start by telling us a little bit about the sort of business landscape. We heard there is this sense that podcasters can be just individuals in the basement, but it is big business these days. And could you tell us a little bit about the current business landscape and how that's evolved in recent years?
Yeah, absolutely. Thanks, Dan. So absolutely, I think you can't really talk about podcast business landscape without talking about its foundation and its origin story. And to Rachel's point, this was a media landscape originally made up of independent creators. These were individuals in their closets, in their basements, who had a microphone and an RSS feed. And I'll get into what that is in a second. But this meant that there was a low barrier to entry into this medium, and they could reach a broad audience. So RSS feed is a real simple syndication feed. It is essentially a web feed where creators could publish episodes of their podcasts, and they would be distributed to a global audience instantaneously. So again, this created a real low barrier to entry to getting these podcasts out into the world and to listeners. It was thought of as an open ecosystem and a really like indie creator DIY ethos. over the past decade, we've seen this business landscape shift significantly. Major media companies, I work at one of them, has invested heavily in this space and made it a really vertically integrated, multi-billion-dollar media industry. So this has been a huge shift, and now I generally think of the landscape as a three-tiered ecosystem. Tier one being these independent creators. They're still out there and they're a really important part of the overall landscape. A lot of amazing content comes out of this tier of creators, but they're still closest to that DIY ethos that harkens back to the origin story of podcasting. I would say tier two are going to be your audio-first studios and production companies. These bring a higher level of professionalism, more resources, and they more often have direct relationships with the major platforms, so they don't have to rely as heavily on the RSS feed DIY upload like the independent creators need to. These are the partners that we're often entering into licensing agreements with directly as a platform. And then third tier is going to be the media platform, which are completely vertically integrated, owning the full creative pipeline from show development all the way through distribution and monetization. What's really interesting to see, particularly being someone who works at the tier three category of players, is how these tiers interact with one another, and I think really learn from and push each other forward. So you're going to have a tier one creator who, through grassroots audience generation, social media, generating a large following on Patreon, they have caught the attention of individuals at the tier three level. This is a creator with promise. This is a creator that if we partner with them and put our machine behind them, we can really help them scale and grow. So that's very much part of the landscape today and a really exciting part of the job that I get to do.
So are you working primarily with sort of in the tier three with original productions done in-house, or are there third-party production companies who are bringing these along?
I would say that most platforms, major platforms, have a hybrid model. So we are producing internally. We have acquired tier two studios like Bill Simmons' The Ringer, where we have brought that entire production house in-house internally. They're still producing their content. They are still furthering the Ringer brand, but that is now under the Spotify umbrella. We partner with talent. Recently did a deal with Amy Poehler. We had our deal with Trevor Noah. So we're partnering with big name talent who often have their own production companies. We find those tier one creators where they have a really interesting back catalog that we're licensing onto the platform. And then we're engaging them to create new content from us on a go forward basis. And then we also have our open platform for tier one creators to upload to. So you may have heard of Spotify for Creators. This is where individuals who are still producing out of their homes, don't have the resources of a big production company behind them, they're able to upload to the platform, they're able to lean into some of the monetization tools that we make available to them and still get their shows out and available on our platform. So really it's quite hybrid. We do work with third-party production companies, we do produce in-house. We're coming at content aggregation on our platform and creation from all angles.
Right. And so on the sort of transactional side of legal issues and deal-type legal issues, what are some of the unique challenges? And you mentioned new monetization streams that come up with platforms, and I'm sure that everyone is used to their favorite podcast being interrupted by an ad for Stamps.com or the host reading something along those lines. So how does that compare to sort of the type of business legal issues that come up with other media?
Yeah, so, I came from a world of TV and film. That's where my career was prior to being at Spotify. And I would say that the core contractual principles that we need to address within a podcast agreement don't differ wildly from what you see in a podcast or a television or film agreement. But I think where the unique challenges come in is the, relative youthfulness of this medium, as well as the fact that it is actively evolving at a really fast pace. So a great example of this, I think, is that at the beginning of, these major media companies having interests and investing in podcasting, the distribution strategy was really around exclusivity. We are going to acquire content. We are going to have that content exclusively available on the platform because this is going to lead to subscriber growth. I think as that distribution strategy has matured across the industry, what we've learned is that actually by making things widely available, we're not capping off our revenue growth opportunities, we're broadening them. So that's been a material shift in the way that we're thinking about our distribution deals and our licensing in agreements, that we have had to and continue to try to evolve our deals with and around. But because of the newness of the medium, I would say that no negotiation ever looks the same with these deals. When I was negotiating TV and podcast deals, there was almost a formula to them that kind of goes out the window when you're working in podcasting.
Yeah. I guess one of the kind of unique things, or at least sort of a signature of a lot of podcasts, is just the hosts reading ads and the way advertising can be integrated into the content sometimes. Are there legal regulations that govern that, or just best practices?
Yeah, no, it's really difficult. And speaking to Rachel's point about the intimacy of the medium, one of the things that sets podcasts apart, I'm sure you've heard it if you have listened to podcasts, is this thing called host-read ads. So this will be where a host is doing their podcast, and then all of a sudden there is a shift, not always a noticeable shift, which can be the issue, to an ad that is being read by that host. This podcast is brought to you by, I always hear the Better Health ads being read, right? It is in that host's voice. It is often in the same cadence, in the same tone as how that host is presenting the rest of their podcast. So where do you draw the line then between, robust First Amendment protections around the editorial speech that's happening throughout the course of the creative component of the podcast, and then the commercial speech that just kind of comes in there, and there's not this real distinction. It's kind of a blurred line between that and the rest of the podcast. So what we advise is disclaimers. We want our hosts to very clearly, very explicitly disclaim that they are reading an ad, they are reading an ad for Better Health, they're sponsored by this company. There can be no confusion amongst the audience as to whether this is a part of the podcast itself or if this is an ad that's being read to them. So that's where we try to mitigate that risk as best we can.
And in terms of intellectual property issues, I think especially in the early days of podcasts, and especially with, I guess, what you were calling the first tier, and with people who are younger and maybe less experienced, there's a sense sometimes that you can just take anything off the internet and use it. But obviously a lot of podcasts make extensive use of audio clips and samples. And so do you find that the approach to fair use differs from other media?
I would say that it is if you're trying to rely on fair use, it is a good medium to do so carefully because it is inherently referential in nature, conversational, and I think that these third-party copyright-protected works that are being incorporated by the hosts are done so in a way that supports, a transformative use, which is one of the fair use factors, and one of the fair use factors that I think is has been found to be heavily persuasive. So a lot of times in what we call the always-on chat format, which is where you'll see a lot of the most popular podcasts falling within that genre. This is going to be hosts talking to one another, talking to guests in a way that feels less formal, it's not as scripted, and they're referencing third-party works in order to comment on culture, relationships, news, current events. So inherently, that kind of commentary is helpful in terms of a fair use argument. What I've found when working with younger producers is they have this concept of, okay, as long as it's 10 seconds or less, that's fair use. And I've been like, no, get that out of your head. And the way that I try to get that out of their head is I go, actually, you can do more than 10 seconds, right? If you have a good, strong, fair use around there, let's not get tied to this 10 seconds or less concept. Yes, the less the better. I say, how much do you need? The minimum amount you need to make the point that you're trying to make with your commentary. And that's where you get into really interesting conversations. This is some of the favorite part of the work that I get to do, because I have a producer coming to me, they're like, we're publishing this tomorrow morning, we're writing the script now, we have to use this. This is something, we need to use this clip in here, or else, we can't even talk about this subject matter, this is key. I go, okay, let me see what your scripting is around that. And working with them to craft scripting and language and really comment upon the content in a way that ultimately, I'm not bragging, but I think sometimes helps push the conversation forward. I've heard that feedback. It's such a great collaborative moment between us and the producers to help craft those arguments.
And so, obviously with true crime, with investigative reporting type pieces, that you always have to be cognizant of defamation concerns, invasion of privacy. I think for those of us who work in, advising journalists and production companies, TV across, traditional formats, there are certain ways that, we can help them to mitigate legal risks, and with context, with attribution, and a lot of that often is either visual or text-based. So how do you deal with that when it's audio only?
Yeah, so when I am supporting a true crime podcast, investigative journalism, defamation is definitely the key issue that I am on alert for, and I am working closely with our producers to mitigate the risk of. I would say in the audio space, what is somewhat not necessarily unique, but more prevalent, is not just defamation by virtue of the words that are on the piece of paper, but defamation by implication. To Rachel's point about the intimacy of the medium, the tone, the cadence, the voice, just the way that these words sound, it's a powerful mechanism, and it can create powerful impressions. So for that purpose, we often rely heavily on the fair report privilege, and that is usually the first shield that I look to when supporting these types of podcasts. So the fair report privilege, it's a qualified privilege under U.S. defamation law, which allows journalists to restate information that is in a government proceeding or official government document, even if that information turns out to be harmful or later turns out to be untrue. This is a very jurisdiction-specific privilege, so there's also work that goes into, okay, what jurisdictions do we think could potentially be applicable here? It's not necessarily going to be the jurisdiction that we're producing out of. And so then we have to look very carefully to how this privilege looks within that jurisdiction and make sure that our journalists are reporting in a way that's tailored to that privilege. But it's a great legal shield and something we rely on heavily for that genre of programming.
Yes, and I should say jurisdiction by jurisdiction. We're very fortunate here in California to have an absolute fair report privilege. It also, when I'm counseling, often will say that it is actually one of the few areas of the law where saying allegedly actually means something. But oftentimes, it's most commonly invoked, obviously, with print media, because you can literally cite to the court records there or explain the proceeding that it's coming from, or even in a true crime TV show, you can flash a reference to it on screen and make clear to your audience that these are not absolute facts, but this is referencing a proceeding where these were contested allegations. And so sometimes is there pushback that it's a little bit too clunky to have to include that? Or?
Oh yeah, no, absolutely. Yeah. That is pushback. And, as we move into out of time here? Okay, sorry. But I think as we move into the video space, it'll be really helpful for journalists, and that's another shift that's happening across this ecosystem. There's so much we could speak to about this. There was a New York Times article that was just came out this week about the shift to video in the podcasting space. It'll hopefully be less clunky. But yeah, the allegedly and the disclaimers and the citations that do need to package around, our reliance on this privilege, it can be difficult. So we work really closely with our producers to ensure that's happening. But yes, there is pushback there oftentimes.
Great, thank you. Well, speaking of podcasts involving weighty and complex legal issues, I want to introduce Dov Fox. Dov Fox is the Herzog Research Professor of Law at the University of San Diego School of Law, where he directs the Center for Health Law Policy and Bioethics, an elected member of the American Law Institute. His recent books include The Conscience of Care, Navigating Health and the Culture Wars with Harvard University Press, and Birthrights and Wrongs, How Medicine and Technology Are Remaking Reproduction in the Law with Oxford University Press. Dov has also created a number of legal podcasts. His first, called Donor 9623, examined the case of a sperm donor who was sold to scores of families as perfect in every way, except it was all a lie. The 8-episode series was named Audible's Best Podcast of 2020 and submitted for a Pulitzer Prize in Investigative Reporting. Let's hear some excerpts.
The parents wanted a child and got a child, and we have said that you cannot really complain if you wanted a child about the child you get.
What does it say about the plaintiffs that say, I have a good-looking guy with high IQ, like that's the baby I want. I don't want dumb baby, I want smart, good-looking baby. There seems to me to be something distasteful of, I'm gonna go on this website and find the best-looking dude who purports to have the highest IQ and the best credentials because that's what I want.
What's it reasonable for parents who go to a sperm bank to expect?
Honesty. That's what I was expecting. Honesty. Let it be my choice. I'm the one who's going to be raising that child. You don't expect perfection, but oh my God, you expect honesty. You're dealing with creating a person, a life.
A sperm bank can completely misrepresent everything about the sperm it's selling and charge whatever amount of money based on those representations and completely lie to every customer it has, and nobody can do a thing about it.
I've made a choice and love her to death. And hindsight, yeah. I would pick a different donor.
And then you would have ended up with a different kid. I wonder how you sort of help her make sense of that.
She said, well, you mean you wouldn't have me? And I said, I know. I said, had I not gone donor, you wouldn't be here. It might be a different version of you, right? And she goes, yeah, but you would so miss me. And I said, absolutely. Yeah, but how would you ever live without me? And I said, I know, I can't even imagine. Yeah, it's hard for her to understand, and it's hard for me to understand.
So, Dov, could you tell us a little bit about how you came to take the subject of your legal scholarship and turn it into this narrative podcast?
Thanks, Dan. Yeah, I'd written a book about the universe of cases involving reproductive harms. So the disputes fell into 3 buckets. One, some plaintiffs ended up without the baby they desperately had tried to have. Others ended up with the very child they had tried to avoid having. And finally, there were those who ended up with a different kind of baby than one they'd had reason to expect. The podcast was about this 3rd bucket that I had a hard time wrestling with on the page because of its emotional resonance and some of these existential stakes we heard about in these clips. This different baby case stood out to me among the hundreds I studied for the book because it involved the most popular sperm donor of all time by many accounts. This guy was a 6'4" neuroscience PhD who spoke 5 languages, played 4 semi-pro sports, His profile in the donor catalog described a Tom Cruise lookalike with an IQ of 160, same as Einstein. So think a cross between Judge Owens and Judge Miller. But with this guy, it was, as Dan said, all a lie. And for almost every week, for like 14 years, he donated sperm every time he wasn't either in prison for various felonies or psychiatric hospitals for severe schizophrenia, a hereditary condition passed along to offspring. So through a fluke email leak, some of the parents found out. Many sued in jurisdictions across the Southeast, but all of these states closed the courthouse doors to parents that were complaining about the very misconduct that led them to have the children they got, who they now love. The law says basically it would send an intolerable message that I wish my own child had never been born. So the podcast tried to give voice to the stories of the different affected parties. So there were these parents who didn't know why their children were suffering so terribly or what they could do to try and help them. There were children who now faced a very scary and precarious future. And the donor himself, he was one among many. Young men saw an ad on a college campus promising an easy way to make anonymous big money. You know, the greatest lesson I think I took away from my time in chambers with Judge Reinhart was to try to look for the impact that the law has on the lives of individuals. So that's what I feel like these more intimate kind of conversations that you get to have in this podcast form allows. I'm under no illusions, Justice Reinhart, or Judge Reinhart rather, would have deeply disapproved of all this podcasting nonsense. And yeah, I think I shudder to think what he would say learning that one of his clerks had become a sperm scholar.
So obviously, as part of this project, I mean, you interviewed the subject, in addition to a lot of the families, and you know, did a really nuanced view of his perspective as well as theirs. Was that one of the key differences between, you know, addressing these issues this way through this format as opposed to through legal scholarship, articles, books?
Yeah, I think that that conversational aspect of the work and also the tone or voice that you bring to bear certainly marks a difference between podcasting and legal scholarship. I mean, this is not, you know, firing off a tweet or a social media post. I do think there are a lot of similarities in the sense that this too involves rigorous research and analysis about what the law is and how it can work at its best, or at least better. But yes, there are a number of differences. I think among them, in this form, don't rely exclusively on written materials, judicial decisions, legislative text, and history. You know, we traffic also, maybe mostly, in human sources. And so that work involves building trusting relationships and having those conversations. Also building a kind of narrative arc that will unfold for listeners across episodes.
Mm-hmm. And can you tell us a little bit about the impact that this project had?
There were, I think, three main ones. First, every case from this donor, 9623, had been dismissed before the podcast came out. A few months after, the Georgia Supreme Court, for the first time, allowed plaintiffs to bring suit, paved the way for a trial, recognizing claims for offspring injuries, for medical monitoring, for consumer fraud. And then citing the podcast, then that decision was cited by a number of other states that went on to rethink their own approaches to these different baby cases. Fact patterns ranging from fetal misdiagnoses to embryo mix-ups. In the latest restatement of torts, I got to help try and untangle this complicated web of doctrines about where they go by the name of wrongful birth, wrongful life, wrongful pregnancy, and try to make sense of them in terms of the legal stakes for the individual parties involved, bring to bear, I hope, a bit more clarity on this area of the law. So one impact was in the courts. I also heard from lawmakers who were surprised to learn, listening to the podcast, that this $5 billion American business of making babies, responsible for 1 in every 42 babies born in the United States today, conceived in a petri dish, goes virtually unregulated across the United States. And they asked what their states could do to try and mitigate the harms that we heard about in the podcast. And so I got to help draft and testify laws about transparency in assisted reproduction, various measures, both state and federal, Colorado, New York, Washington. And so those laws have, the legal landscape is beginning to change as well on the ground through these statutes. Finally, I heard from a lot of parents and other affected parties all over the world, actually, starting here stateside, from a lot of reproductive professionals, OBGYNs, reproductive endocrinologists who were feeling the force of the law after Dobbs, in light of abortion bans that were enacted in the wake of the fall of Roe v. Wade. There were also a lot of families of donor 9623 who learned for the first time listening that their own children carried these genetic risks and wanted to know what they could do to help and mitigate some of those harms. There was a New York couple who lost their son after he took his own life. They found out only too late that he had been at risk of schizophrenia, and so they learned of his diagnosis without enough time to help treat it. There's a federal bill now pending. State lawmakers in New York have introduced, named after their son, Stevens Law. And there were families who wanted to meet the donor himself, or rather whose kids were now coming of age and who really wanted to meet him. And so a number of these stories then took successive seasons of the podcast, from tort law, where it began, to family law, criminal law, and constitutional law.
So, I sort of opened this with the quote about the free press, and, we obviously have, through Rachel and Whitney, representatives of the media. But also, we have folks like you, Dove, who sort of come from this world, the world of attorneys and, judicial clerks and law professors. But when you do this kind of work, you are the press, you are disseminating information to the public. So how do you balance those roles, and do you think this is something that more law professors should do?
Yeah, so two thoughts. One is that I see a big part of our jobs as law teachers to try and communicate useful information to the legal community. And so, as we heard from Whitney, as we are consuming information in new ways, I think it's incumbent upon us to think about how we can produce it in ways that match. So every time I have occasion to write a book or series of articles, I then also make a new podcast that develops some of these themes for a wider audience. Should more law professors do it? I have an especially supportive dean. I think for more law professors to do this work, it would probably depend on the Academy's willingness to rethink the role of podcasting within broader scholarly standards for things like hiring, tenure, and promotion.
Thank you. Well, speaking of the Legal Academy, our next speaker is Melissa Murray, who's the Frederick I. and Grace Stokes Professor of Law at NYU School of Law, where she teaches courses including constitutional law, family law, and criminal law. She's the author of Cases on Reproductive Rights and Justice, the first case book to cover the field of reproductive rights and justice, and the co-editor of Reproductive Rights and Justice Stories. Prior to joining NYU Law, she was a professor at the University of California, Berkeley School of Law, where she served as interim dean in 2016 and 2017. In addition to her scholarly work, Melissa has written for publications such as the New York Times, Vanity Fair, and the Huffington Post, and many of you have probably seen her as a legal analyst for MSNBC. And, relevant today, especially, she's the co-host of Strict Scrutiny, a weekly podcast from Crooked Media, in which she and her fellow law professors Leah Littman and Kate Shaw provide legally rigorous but accessible and irreverent commentary on the Supreme Court. So I thought I would ask, Melissa wrote an article along with her co-host titled A Podcast of One's Own. You can find it in the CLE materials for today. That talks about the homogenous nature of the Supreme Court's ecosystem, from the justices, clerks, and advocates to journalists and pundits, and explains, quote, "We wanted to do something to remedy these disparities, to highlight the voices of women and people of color, to celebrate the expertise and skill of lawyers who work on behalf of the less powerful, and to challenge prevailing views about what a Supreme Court expert looks and sounds like. Starting our podcast, Strict Scrutiny, was a small step in that direction." So can you tell us a little bit more about why you chose a podcast as the way to do that?
Well, first of all, thanks so much for having me. It's great to be here back in the Ninth Circuit. As someone who has apparently been exiled to the East Coast, it is lovely to be back here, so thank you for having me. We began our podcast in 2019, and I think our principal motivator was our very deep-seated belief that the courts were doing important work that had real and material impact on the lives of real people. And although there was a glut of information about what the executive branches did and what the legislature did, there was very little commentary on what the court did. And we thought that was a major oversight that we could remedy. When we were looking at what was available in terms of commentary on the courts, and in particular the Supreme Court, we did see a startling degree of homogeneity among the court commentariat. And we thought that had real consequences. One of the consequences, I think, for that kind of homogeneity is that when you are covering the court, there is a tendency, I think, among that sort of traditional commentariat to adopt a very studied neutrality in how you talk about the court, to present the court's work in a kind of abstract way where you talk about, well, they did this, but you could do this, and a sort of both sides about it. And I think that is really possible to do, that sort of abstraction and that neutrality, if you have less skin in the game. But from our perspective as women, as a woman of color, we felt like we had a lot of skin in the game, that the court's decisions, this was in 2019, the run-up to Dobbs, we felt that the work of the court was having material impacts on our lives, and that we couldn't be neutral about it, and we didn't want to be neutral about it. So when we started the podcast in 2019, we were very clear. This was not going to be a podcast of studied neutrality. We were going to have takes, and maybe our takes would be a lot. If it was too much for you, then you could go find less. And we were very clear about that. This isn't a podcast for everyone. If it's not for you, there are other podcasts that may be there. But we wanted to provide a podcast for people who felt like they had skin in the game, they were invested, and the work of the courts was having a material impact on their lives, and they wanted to talk about it. And we wanted to give them a space to hear other people talking about that. So that, I think, was the principal motivator for us, thinking about the court, bringing the court to the forefront, and not just the court, but the lower federal courts and the state courts as well, making clear that the judiciary was a major part of how we construct the legal fabric of our lives. Why a podcast? I think everyone has been very clear about this. There's something sort of small d democratic about a podcast. If you have an iPhone, you can have a podcast, which is not to say that if you have an iPhone, you should have a podcast, but there are very low barriers to entry to this medium, and more importantly for our purposes, there's something about a podcast episode, whether it is 20 minutes or 30 minutes or an hour, that gives you the luxury of time to unpack a concept and really explain it, maybe in the way you might in a classroom. And there's something about the arc of a podcast season that allows you to develop concepts over time. Maybe it's a catchphrase like stare decisis is for suckers, that your audience can resonate with, and it becomes meaningful over time, a kind of shorthand that an entire community of listeners can adopt and buy into. And so to us, that was the real value of this, as opposed to doing cable news, where you have 5 minutes to have a conversation with a host about something that is incredibly nuanced and complicated, and you may surface something about it, but you won't be able to dig into it in a way that feels satisfying. So this was, a way to do that. It was also, I think, an alternative for us to really say what we were thinking in a way that I think we don't feel we can do in the classroom, where I think we are more both sides, more neutral about what we are presenting, because we want our students to adopt and develop their own views about the material.
Yeah, I mean, obviously it's a very different audience than when you're writing academic scholarship, but I mean, I'm curious, do you have a kind of a particular listener in mind when you're producing the show, or do you have demographic information about who's listening?
So we know there are a lot of lawyers who listen to the podcast. Maybe people in this room listen to the podcast, but we really wanted to make a podcast for people who were lawyers and who are not lawyers. One of the things we said when we started was, like, we wanted our moms, none of whom are lawyers, to be able to listen to this podcast and come away knowing something about the legal landscape that they didn't know before, that anyone could engage, even if they hadn't been to law school. And so that requires us to do more to promote our sense of legal accessibility on the podcast. So, we don't say things like, this case was digged, without explaining that a dig is a dismissal because certiorari had been improvidently granted. When we talk about an order from the court seeking the views of the Solicitor General, we don't use acronyms until we first explain what that might be. So, I take this because this was something that was really serious to me. And when I went to law school, I started in 1999, and I had Judith Resnick for a professor, and I remember she was talking about res judicata one class session, and I turned to the person sitting next to me. I was like, who is Ray? Where did Ray come from? I don't remember Ray. Was he the plaintiff? And the guy sitting next to me, whose father happened to be the president of the university, very kindly explained to me that Ray judicata was actually res judicata, and he was a concept and not a person. But I have never lost sight of that. Like, if you are someone who doesn't come from a family of lawyers, there is a huge barrier to entry to the law, just in the vernacular that you have to learn and become fluent in. And I don't take for granted that my students know that language, and I don't take for granted that our listeners know that language. And so I start every episode thinking about res judicata and how I can break it down for everyone else.
And so obviously, just in the last few years, since you started the podcast, there's been a huge change in, the role of podcasts, as, Whitney was talking about, and obviously a lot of changes at the Supreme Court. So wondering how that's sort of like affected the mission, and, how you saw it originally, and, what your thoughts are today.
So when we started in 2019, I think we believed very firmly that the Supreme Court was on the precipice of overruling Roe versus Wade. We were told by other people that we were hysterical women and that this was never going to happen. Hello. We were right, and I think we were right to sort of create an audience with that mindset in mind, because when it did happen in 2022, I think our audience was poised and ready to really dig in to what that was going to mean. And we had been talking about that and building up to that. We had a lot of lucky breaks along the way. I don't think they felt lucky at the time, but one lucky break was the pandemic. Who knew that the pandemic would be a lucky break? But one of the things that happened in 2020 that we did not anticipate when we started in 2019 was that the court would be forced to begin live streaming their oral arguments, and they have not stopped doing that since. And that meant we now had not only real-time engagement with the court, where we could listen to them, an oral argument, and then respond in real time, whether it was online in social media or immediately in the podcast, but we now had an audience of listeners who were ready to do the same thing. So there was more of a dialogue going on, and we just didn't have any expectation that that would happen when we started in 2019. The other, I guess, lucky break for the podcast, I mean, the silver lining for the podcast, is that we had a lot of developments on the court, whether it was changes in personnel or simply a change in the way the court's composition would impact the approach to taking cases, to granting certiorari, and ultimately deciding the cases. So there was just a lot of grist for the mill that we had an inkling would happen. We mostly thought it would be around abortion and Dobbs, but it really actually became a topic in a lot of different areas, and I think fed our interest in the court and the public's interest in the court, which the podcast was then able to sate, but also I think helped build an audience for other entrants. The idea that ProPublica would have an entire series thinking about and probing the disclosures, the financial disclosures of the justices, I don't think we anticipated that in 2019, but it has become part of the ecosystem and part of what we cover too.
And I should ask the same question that I asked Dove, do you think this is something that more law professors, more lawyers should be doing?
It's a really good question. I will say this, I began podcasting in 2019 well after I had gotten tenure, and indeed after I had left Berkeley for NYU. And one of the reasons I was able to do it was because at NYU, I just was freed from some of the administrative work that I was doing at Berkeley, and I had more time. And that was literally the only reason why I felt like I had room in my life to do this. I think there were real advantages for my work as a law professor for doing this. So, one of the articles I think has been one of the best things I've written in recent years is a piece in the Harvard Law Review called Racing Roe that talks about the ways in which there has been an effort, largely stoked by Justice Thomas in a shadow docket concurrence called Box versus Planned Parenthood of Indiana and Kentucky, to associate abortion with the history of eugenics in the United States and what he calls a sort of racial genocide history of eugenics. And I was able to sort of formulate an argument about how you might undermine Roe or indeed any other precedent by looking to its embeddedness in a kind of racial injustice, only because we had covered all of the court's cases that term, including Ramos versus Louisiana, which was a case about non-unanimous jury verdicts where the court overruled a 1972 case, Apodaca versus Oregon, on the view that the Apodaca court had not considered the way in which the non-unanimous jury rule had been part of a Reconstruction era effort to sideline and undermine the participation of Black jurors on Reconstruction juries. And I saw in the Ramos case and the court's appreciation of that history something that Justice Thomas was trying to do as well in the context of abortion by linking the technology of abortion to this history of eugenics and racialized genocide. I don't think I would have been able to tease that out if we weren't covering the whole of the court's docket. So in that sense, it has been an enormously fruitful complement to my work as a law professor. But again, this is something I did post-tenure. I would not have done this pre-tenure, and I wouldn't advise anyone else to do it pre-tenure. This question, though, that you're asking, and I think you asked it also of Dove, that I want to sort of talk about is like, what does it mean for a professor to also be a podcast host? And I think there are some who think that law professors shouldn't have podcasts, or at least not this podcast. And I think there are some who think that this medium isn't quote unquote professorial. And I think to that I would say it's not lost on me when I go before a classroom that I have students who have never had a law professor who is also the co-host of a podcast, or a law professor who made regular appearances on cable news. But by the same token, I am very sure that when I look at my students, that there are many of them who have never had a professor, whether in law school or in any other institution of higher education, who looks like me. And I'm very sure that when I was the dean of Berkeley Law, that there had never been another dean at a top 10 university that looked like me. And so I say all of this not to be self-congratulatory about it, but to make clear that the entire time I have been in the legal academy, it has been an exercise in breaking barriers and in renegotiating norms about what it means to be professorial and to occupy this space. And so I see this as merely a continuation of what has been a journey that has not necessarily been my choice, but has certainly been my experience.
Well, thank you so much. And thank you to everyone who submitted questions. We have a great set of questions here, so let me read a few of them. As podcasters about the legal system, how have the recent attacks on the judiciary changed how you view your roles as journalists or educators, if at all? So maybe Rachel, if you have like a journalistic perspective on that, and then invite anyone else who wants to jump in.
I mean, I think that as journalists, you always have to be very clear-eyed about your role and what it is that you do. And I know that in the work that we do, the most important thing is to remain fair and balanced. And obviously, yes, those attacks on the judiciary are happening, and we know that there's also a lot of attacks on journalism and journalists too. And so it's a short answer, but I think it's a simple one, is that the most important thing is to keep our ethics and our, certainly in the work I do, the balance, above all, is our priority.
Okay. So I think there are some who argue that the attacks on the judiciary might be coming from strict scrutiny. So I will just say this. We take all of it as fair game. So we have read from opinions, we read the opinions of the lower courts, of the Supreme Court, and we talk about them. If we think that something is amiss, we say that, and we're very clear about it. And not everyone will have the same take as we do, but we believe very firmly, and I think other people, maybe even the founders might believe this too, dissent is not necessarily treason. It isn't treason. I mean, a democracy can only exist because of dissent. So when we call out the court for doing something, it's not because we hate the court or we want to invite more criticism of the court, but we do think that it is worth talking about. This is inconsistent. Last week, we did an episode on the Supreme Court's shadow docket decision allowing the dismantling of the Department of Education to proceed. And one of the things we talked about is it was entirely inconsistent with the court's earlier shadow docket ruling regarding the Biden administration's request to continue the student loan relief program while the litigation on the constitutionality and propriety of that program was pending. And the court said, no, it allowed the injunction to remain. And here, it stayed the injunction. That's an inconsistency that is worth covering, and it can't be the case that calling out that inconsistency is an attack on the court. That is analysis, that is an observation, and that's exactly what citizens in a democracy are supposed to do.
I think that's just right. There's nothing especially different or more threatening, I think, about this medium with respect to judicial independence than law review articles, books, online journals, blogs. I think what makes it feel different is that it reaches more people. And Melissa and her co-hosts are, they're just wickedly entertaining. They're deeply irreverent. And so that feels different in that I think it pierces a veil that of some kind of a sacred cow of worship, and is in part, I think, required to democratize these ideas and this work. And of course, it is not just public in a formal sense, but public in a deeply important sense, that this is law for us all, that affects us all. And that I think it's only a welcome and wonderful development that it is being shared in ways that can more readily include us all and be accessible to so many more than it had before. And for those who complain to Melissa or who think that that strict scrutiny, that the voice and opinions that they share are unwise or unfair, then they can try and find folks who are as funny, as insightful as they are to develop their own podcast, to develop their own ways of sharing contrary ideas and beliefs. And this seems to me like a very happy development. Yeah.
Well, here's a related question, but one that specifically focuses on the portrayal and participation of judges in podcasts. So the question is, given federal judges are public figures under Sullivan, that many podcasts are largely unvetted by responsible legal counsel, and judicial decisions today often invite calls for impeachment or worse among members of the executive and legislative branches, explain why any federal judge should want to grant an interview. So maybe I would be curious, again, from the why they would want to grant an interview to a journalist doing a reporting-based podcast, and maybe why they would want to go on as a guest to an analytical, commentary-based podcast, maybe if Rachel, Melissa.
I mean, I would always encourage people to come and do an interview with us. We obviously, I think that question is talking mostly about perhaps independent podcasters and people who do not come from a traditional media outlet where I might be working. And so I can always say that whenever we broadcast anything, we do so fairly, and we always would suggest to people they would do an interview with us, because we would always want to represent everybody in a story in a way that we're portraying them. And I would offer people a very fair interview, but I'll let the rest of the panel take that one.
Well, to be very clear, we've never actually asked a sitting judge for an interview. So if you were looking for an invitation, I think you may have to approach us. But we recognize that you occupy a particular role. We would never want you to compromise that. I think the only person to whom we've offered a spot on the podcast was Justice Breyer. In the wake of his retirement, we offered him a special segment on the show that we were going to call Mensch on the Bench. He did not respond. The offer is still open, but call us, Justice Breyer, if you're interested. But we have your words. I mean, we don't need you to come on necessarily, because we have your words. Like, we have oral arguments from you, we have what you have written, we've got plenty of grist for our mill, and we work from the assumption, I think you work from that assumption, that you are saying what you mean, and you are relying on the text of the Constitution, the text of statutes to write these opinions, and we're just digging in. So, not to say we don't need you, we obviously need you to do the work that you're doing, but we don't necessarily need you to come on the podcast unless you want to, and if you want to, just let us know.
To all you menches on the bench, I think it would be a terrible mistake for you to do that. Deeply misguided. I think you do. You occupy a different role, and I think it makes sense to be deeply reluctant to engage in these conversations in a different space and role. I mean, just as can you imagine, sharing a dissent by video? There are certain things that it would be hard to imagine judges in their role to break with norms and pioneer, distinctive ways of communicating with the public.
How about, maybe a retired judge, or do you think there's ever a circumstance, maybe where a case has run its course, where it might be appropriate or helpful? I'm thinking, this is going way back now, but there was an article in the LA Times that won a Pulitzer Prize for feature writing by a journalist named Barry Siegel that told the story. It was a very tragic case about a father who had been convicted of negligent homicide for the death of his small child under very tragic circumstances, and it was about the judge grappling with these issues of the purpose of rehabilitation and punishment. I think he had ended up sentencing him to a day in jail, thinking that would further his interest in coming to terms with this, and I think he had ended up committing suicide. It was a tragic story, but it was really incredible the way that the judge opened up and talked about this after the fact. That it might be a unique situation, but I mean, do you think there's ever a situation where having a judge really talk about something like sentencing decisions and the ethical, moral issues that go into it and how it affects the judge personally might have a place?
Yes and no. I think to bring out the moral stakes, the right and the wrong, that animates so much of the law, strikes me as deeply important. To pretend that these are not deeply moral decisions with ethical stakes is, I think, obvious to everyone. And so there is no need to hide and submerge, whether bringing out some of those personal questions, so thinking about Stephen's family, I'm thinking about our kiddos who are here, so excited about the aquarium in a couple hours. I think we don't want to think of judges as bringing to bear those personal considerations for better or worse, and I think indulging that fiction has some merit.
Okay, well, here's one. I'm almost out of time, but here's a good one. Does the Washington Post or the Wall Street Journal provide a fact-checking site for podcast post-production? Why don't we cross out Washington Post and say Spotify instead?
You can go ahead.
Fact-checking for post-production, I can say, this is a short answer, we use fact-checkers on all of our podcasts, and I think that one thing that would be really useful is when I'm putting a podcast script together, I will use footnotes and citations all the way through it. I think it would be really helpful for us to be even more transparent, actually, with our audience about where we source and where we get our material from. Like Melissa said, it's not just something we throw together, they are academic essays.
Okay.
All right. Thank you very much to our panelists. That was an excellent discussion.